we challenge it in the Supreme Court, and it's a reported judgment of the Supreme Court. But we must remember what happened in Gujarat. 27th February of 2002, the Godhra massacre took place. He says that the law and order is completely collapsed. This is NHRC's report. Before anybody came in, before Zakia Jafri complaint came or anything of that sort, NHRC makes a report. This is what has happened. हिंदी अच्छी नहीं है, मेरी बम्बईया हिंदी है, सिर्फ बम्बई वाले लोग समझ सकते हैं, शायद जस्टिस मार्दपाले समझ सकें, लेकिन बाकी कोई नहीं समझेंगे। इसलिए मैं अंग्रेज़ी में बात करूँगा, बीच बीच में अगर कोई क्वेश्चन है तो हिंदी में बोलने की कोशिश करूँगा। See, one thing we must realize about both Himanshu's case as well as Zakia Jafri case judgments. Both those judgments came before anyone was tried and convicted or acquitted. Okay? There has been, I mean, this is I can understand a judgment coming which says at the end of a trial, after things have been tested in cross-examination, in examination chief, documents are presented, that somebody deliberately tried to do this, somebody deliberately tried to do that. Here we are faced with a situation where before even a trial begins, okay, before even a trial starts, or before even a trial is allowed to start, okay, people have been targeted, people have been, okay, before even the trial starts, people have been targeted in the sense that they have been, I mean, because of the actions of the Supreme Court, 2 people are already in jail, others are in queue, I guess. They might be not at all scared, but the fact of the matter is that they are in the queue. So that's the reality. As far as the merits of the case, because I believe the Supreme Court judgment in Zakia Jafri is wrong on both the counts. First, it is wrong on merits, which Nizam has already explained, so I will not go into it. And second thing is, it is wrong also in making observations against Teesta, Shri Kumar and others, okay, which basically dismisses their entire, virtually, like for Teesta, it's like dismissing her entire life's work. You know, for 20 years she has been, and if only they knew that she had, I mean, I know that because I was there in Gujarat from 2nd March 2002 onwards. Teesta was also there, that we were not working in air-conditioned cabins as the judges seem to suggest. Okay? There was huge amount of groundwork done, okay? Huge amount of going to the areas, staying in the camps, okay, for days together in order to understand what the problems of the people were. So that's one thing. But the other thing which I think we need to look at is the Supreme Court keeps on saying that the pot has been kept boiling for 16 years. 2006 was the complaint, 2022 is the judgment, so the pot has been kept boiling for 16 years. But we must remember what happened in Gujarat. 27th February of 2002, the Godhra massacre took place, and immediately on that day in the evening, the massacre of the Muslims starts. On 28th, the events which Tanveer described happened, not just in Gulbarg society, but in various other places across Gujarat. And on 1st of March 2002, the National Human Rights Commission takes suo motu action. In 3 days, they realize what is happening is really very sad. National Human Rights Commission, at that time, before the legislative manipulation came, was presided over by a retired Chief Justice of the Supreme Court, and had also other Supreme Court judges as members. They take suo motu action on 1st of March Okay. In March itself, they visit the chairman, that is the retired Supreme Court Judge, Chief Justice, visits Gujarat for 3 or 4 days, meets people, goes to camps, meets people, makes a report, and in that very report, he says that the law and order is completely collapsed. This is NHRC's report. Before anybody came in, before Zakia Jafri complaint came or anything of that sort, NHRC makes a report. This is what has happened. Again in May, they file a second report saying that the FIRs, the police are botching up the FIRs deliberately, and you need to change all the executive officers. They make a recommendation. They say the camps facilities are very bad. They say that the hate speeches which are going on are very vitriolic. This is what the NHRC says by May 22 in their own reports. The pot was already heating up then, and by the by a retired Supreme Court Chief Justice. Please understand that. Pot doesn't start boiling in 2006. In 2003, NHRC, in one of its rare moments, goes to the Supreme Court, files a petition. 2 petitions are filed. One petition is in respect of Zahira Sheikh, Best Bakery case, where NHRC says very categorically, NHRC says that look, that case has collapsed because of the kind of atmosphere which exists in Gujarat today. Obviously, who is responsible for that atmosphere? We all know. Okay. So, because of the kind of atmosphere, in 2003 they filed a case saying that Zahira Sheikh's case, where everybody has already been acquitted, should be retried and should be transferred outside Gujarat. NHRC files a petition. After that, Zahira also files, Zahira and Tisra file a petition, but NHRC takes the lead in this. In that petition, the Supreme Court comes to the conclusion that yes, the situation in Gujarat is not something by which we can allow the trial to go on in Gujarat. A retrial has to be conducted, it has to be moved out of Gujarat. Why did the Supreme Court say that in 2003 if everything was hunky-dory, as the Supreme Court now seems to be suggesting? So in 2003 this happens. 2003 itself, and this is important, before the matter, I mean when the matter was pending in High Court, an appeal in respect of Best Bakery was going on in the Gujarat High Court. Gujarat High Court, while deciding that appeal, makes an observation that Tisra Satalwad and Mihir Desai, that is me, are anti-national people. It's a statement in the judgment, okay, are anti-national people and should not be tolerated. You know, this is an observation made in the judgment in 2003. We challenge it in the Supreme Court, and it's a reported judgment of the Supreme Court, where the Supreme Court says that without giving an opportunity of hearing to these people, under what provision of law you are making remarks against these people? And they strike down these remarks. And now see what happens now in 2022. Shri Kumar is not before the Supreme Court. Tisra is before the Supreme Court. But Supreme Court in its para number 2 says that we are not deciding on the locus of Tisra, we will treat this as an appeal only by Zakia and not by Tisra. So technically, Tisra is also not before the Supreme Court. On what basis does the Supreme Court then, which gave an order in 2003 saying that nobody, you can't castigate people who are not present before you without giving them an opportunity of being heard as to why you are castigating them? On what basis is the Supreme Court doing it today? That's a question which is very important. Again, in 2004 or towards the end of 2003, National Human Rights Commission, now presided over by another retired Chief Justice of the Supreme Court, files a petition in the Supreme Court saying that Gujarat situation, and they are doing reports from time to time. They have appointed a special reporter saying that the Gujarat situation is bad. There are 8 trials which are very, very important, which included Gulbarg, Naroda Patia, Naroda Gam, Gojara, etc., various trials which are very important, and those trials should be shifted out of Gujarat. This is what the NHRC is saying. In 2003 and 4, Supreme Court recognizes what the NHRC is saying and stays all these trials. The pot was was already boiling by that time. 2003, the Supreme Court, on recognition of the picture brought before it by NHRC, says that these trials have to be stayed because things are compromised in Gujarat at various levels, from top to down. One of the observations where people remember that when Gujarat was burning, the Neros were fiddling, that observation comes in the judgment, okay, in the reported judgment. Next. This is what happens in 2003. In the meanwhile, in 2002, the elections are due in Gujarat. Elections are due in Gujarat in 2002, and at that time, the Election Commission makes a visit to see if the situation is ripe for having elections, fair and free elections in Gujarat or not. The Gujarat government makes a very strong case that the situation is ripe for having elections. There is one officer who files a report before the Election Commission saying that no, the situation is not ripe. This officer was Shri Kumar. In 2003, what does the Supreme Court say in its judgment? That in 2005, after he was denied promotion, he starts talking. No, in 2003, 2002, the Election Commission's report discloses that Shri Kumar has filed this report. It's an open decision. It's not something, it's not a sealed cover procedure. Shri Kumar files various reports. Before, and he was the Joint Director of Police Intelligence at that time, Additional Director of Police Intelligence at that time. He files reports repeatedly with the government saying that, look, things are, let us allow me to take action against the newspapers, allow me to do this, allow me to do that. Nothing. Nothing. So what do you do? Then he goes before Nanavati Commission, files affidavits. He is told that unless he withdraws what he is doing before the Nanavati Commission, he gets a notice in 2004. Where unless he withdraws what is going on before the Nanavati Commission, we are starting an inquiry against you about how you were appointed in 1999 as a Director General. This is a notice issued to him before, this is after what he does. Then of course he is not granted promotion. He continues filing affidavits. Supreme Court says that, oh, Shri Kumar filed affidavits only after he was denied promotion, without recognizing the fact that he was denied promotion because he filed affidavits, because he filed reports. This is the reality of, and so, while we talk about tea stuff, we should not forget about Shri Kumar, who, I know Shri Kumar from about 10-15 years, an excellent officer, total integrity, total dedication to his work, okay, will not do a wrong thing, is not residing in some fleshy house, he has his own house, right now of course he is in jail, but that's the situation. This is how and this is the basis on which he is now in jail. Right? And the order which rejects his bail, the Sessions Court order, says one thing, that he dared to file affidavit against the government. Therefore, his bail has to be denied. This is the level at which we are. Coming back to my chronology. So So now by 2006 you have the affidavits of Shri Kumar, which depicts how things were happening, and by the intelligence head, okay, depicting how things were happening and how there was a clear case of conspiracy, how everybody was, you know, hand in gloves with each other in doing this at the top level. There is also a people's tribunal which is set up, okay, presided over by Justice Shri Krishna, Justice Sawant, Justice Suresh. Justice Sawant was a retired judge of the Supreme Court, Justice Suresh retired judge of Bombay High Court. Teesta was the secretary of that. I was also part of that. One day when we were sitting in an office in Ahmedabad discussing what to do, we get a call. The call is from Haren Pandya, who was then a minister in the Modi government. Haren Pandya tells us that I want to talk to you people, but I'll talk confidentially, nothing should be disclosed. Okay? So I'll meet you at a given place, come and meet you. So 4 of us were there, Haren Pandya comes. Haren Pandya tells us that look, on 27th February 2002, a meeting took place in Mr. Modi's house, where Mr. Modi gave these instructions that let Hindus vent their feelings, police should not interfere, okay, for 3 days. Okay. He was a minister. And he discloses this. He tells us, don't tell it to anybody. I mean, don't disclose my name. You can say this, the meeting took place, but don't disclose my name, because I am a minister and I am fearing for reprisals. We don't disclose the name, but somehow, and Shri Kumar says in his affidavits that I was asked to track the movement of Haren Pandya. 6 months later, Haren Pandya gets killed. Okay, now how, when, there are a lot of versions to it, I won't go into that. Now, this fact also came before us. So in 2006, there was a lot of material available by then, that what happened, say, in Gulbarg, what happened in Naroda, what happened in some other place, was not just a spontaneous outburst because of what happened in Godhra. It was much more pre-planned kind of an either inaction, deliberate inaction, okay, or deliberate action. It is in that context that in 2006 a complaint came to be filed by Zakia Jafri, saying that look, I mean, while you are going into Gulbarg, this, that and the other, do not ignore, I mean, while there may be some spontaneity here, spontaneity there, it was something which was a deliberate plan at a larger level. There were hate speeches, there were various other things. So do not only confine your investigation to individual cases. Look at the larger conspiracy, the larger interaction. That was what the complaint was about in 2006. She goes to the High Court because her complaint is not acted upon by the police authorities. High Court rejects the petition and she manages to reach the Supreme Court then. Because that's a legal procedure available within our hierarchy. You go to the High Court rejects, you go to Supreme Court. That's what she did. In the meanwhile, those 8 trials, which had been stayed by the Supreme Court in 2003, which I told you, come up for hearing in 2008. And at that time, the Supreme Court says that, look, we are not transferring these trials outside Gujarat, but we will not allow the Gujarat police to investigate this. We will not allow their special PPs chosen by them to try these cases. We will appoint instead a special investigating team. So even in 2008, please understand this, the Supreme Court is not trusting the Gujarat police. The Supreme Court is not trusting the prosecutors who are supposedly selected after an advertisement and interview and all that. Okay. The Supreme Court is not trusting any of this. Even in 2008, the pot is boiling already. Okay. We have not started boiling the pot. NHRC did it, Supreme Court has been, and remember one thing, this, and then the Supreme Court says the same SIT will also look into Zakia Jafri's complaint. Okay? Supreme Court says that. Finally, please remember that SIT case, the NHRC case of 2003, came to an end in 2018, okay, in the Supreme Court. It took 15 years for the Supreme Court to decide that case. 2018 it was finally disposed of. Anyway, Zakia Jafri's complaint carries on. Finally, the investigating agency SIT says we have completed the investigation. We are so the court says that, okay, now you have to go back to the magistrate, and court specifically says in its order that if you are dropping any of the 63 accused from this, and one of the 63 accused was Mr. Modi, and then there are various other accused who were named in that complaint. If you are dropping any of these accused from your charge sheet, you must give notice to Zakia Jafri and hear her. This is Supreme Court's order in 2011. So they drop all the accused, forget one. Okay. So they drop all the accused. Now when they drop all the accused, obviously they give notice to Zakia Jafri. Why? Not because she is jumping up and down to come and intervene. Supreme Court has said you must give notice. We haven't, I mean, the Supreme Court's order. So we are just complying with Supreme Court's order by going there and filing. And the normal method of opposing a closure petition is by filing a protest petition. So we file a protest petition, which is rejected. We go to High Court, rejected, we go to Supreme Court.